Fortunately for us, the Bombay High Court accepted with our submissions. So twice we succeeded before Bombay High Court. And the reasoning of the Bombay High Court you can still go through, far more sounder than the Supreme Court. Transaction structured so as to achieve object of discontinuing operations of HTIL in relation to the Indian mobile telecommunication operations by transferring rights and entitlements of HTIL to VIH BV. HEL intended to be the target company at all times. Transfer of controlling interest in HEL was the purpose of the transaction. Sale of CGP share was only a part of this arrangement. Share purchase agreement and other framework agreements clearly showed that something other than the Cayman share was also transferred. Valuable rights came to be recognized and conferred the term sheet agreements. These were tangible rights having a direct nexus with India. Supreme Court says they are not tangible rights because they are yet to be converted. We are not on that. Still they were valuable rights. Simplistic to assume that the entire transaction between HTIL and VIH-BV was fulfilled merely upon the transfer of a single share of CGP in the Cayman Islands. Transaction involved transfer of a bundle of rights. Diverse rights and entitlements enabled VIH-BV to control operations carried out in India and thus had a direct nexus with India. Various tangible rights transferred to Vodafone constituted capital assets under Section 2, subsection 14 that were situated in India. FIPB approval indicated that the transaction was subject to Indian foreign investment laws and thus had a sufficient nexus with Indian territory. Section 9 had a wide amplitude and included income from any source arising directly or indirectly. Transaction to be viewed from a realistic perspective. Giving effect to the business common sense was the touchstone, like the common perception test. Scope of Section 195, not restricted to residents. If the sum was chargeable under the Act, TDS obligation was not extinguished merely because the payment by a non-resident to another non-resident. Then, what were the relevant factors that were considered by the High Court? Discontinuation of Hutch operations in India, which generated a profit of Hong Kong dollars 70,502 million, as reflected from Hutch's interim and annual reports. SPA itself, the share purchase agreement, defined the company's interests to mean aggregate interest in 67% of the issued share capital of HEL, not Cayman. Then Ernst & Young's due diligence report records CGP was not originally within the target group and was added much later. Then Carvar, legal effect, transfer of HEL in this case of a transaction cannot be displaced by probing into the substance of the transaction. Then Kanchenjunga Seafoods Limited, CIT, there was a case where a non-resident having received charter fee in the shape of 85% of fish catch in India, sale of fish and realization. Here what happened was, there was an agreement between a non-resident and a resident, and a fish trawler was chartered, and in terms of the agreement, the non-resident was to get about 85% of the catch, which was to be catch of the fish, which was to be mostly fished around the exclusive economic zone of India. But what happened was, after the fish was caught, they were brought into the Indian territory for the purpose of valuation, and 85% was then re-exported. But the matter came up as to whether the transaction attracted Indian taxation and as to whether the Indian who was obliged to actually give a charter fee in the shape of 85% of fish catch is obliged to deduct tax. the Supreme Court held that since the entire valuation took place within the territory of India, you are bound to deduct tax. Applying that principle, here also the enterprise valuation was based on the Indian company. And then you paid the consideration based on the enterprise value. This judgment was cited, but Supreme Court brushes this judgment aside.